Without further ado, we've got Teresa Santoro with Germani Title and Closing, and she's talking about how divorce may affect your real property. It's a huge question that comes up. I'm actually working with several clients right now that unfortunately are going through this, and there's a lot, at stake here. There's a lot of unanswered questions people may have, and Teresa, you can get into that, how a divorce may affect your real property.
Yeah, and it's a very emotionally charged situation. It's very sensitive, and your marital home is, where you built your life, and it usually is the greatest single asset of your marriage. So, it definitely is a point of contention in your divorce, given its financial and emotional value to you and your family. So all those listening should really understand both their legal rights and economic realities before making any decisions. And if you have children thrown into the mix, that their needs become yet another factor in the division of the property and who gets what. So obviously your house is an asset, and it's therefore subject to division under the state's property division laws. So Rhode Island has equitable distribution of assets statutes and laws and case law that determines or guides really the judges and the attorneys to figure out who is going to be entitled to what. And you'll want to know what percentage of the house belongs to you and whether the court would have, ordered the house conveyed to you or to your spouse. And obviously every state is different, so always, consult an attorney, whether you're Rhode Island or Massachusetts. I happen to be both, but make sure you're talking to an attorney about what the laws are in that specific state that the property is located in and where you live.
Sure.
But as you can see also, when you throw kids into the mix, there are practical considerations, not always just what the law states or what the statute says that will dictate who gets the house, the terms of any buyouts that you have, or whether the house is ordered sold to a third party and you guys split whatever proceeds or whatever might be left. So just to clarify, equity is the market value of the house, less or minus any debts or liens against it. So equity obviously is established by determining what the current market value of the home is at the time of separation, less your debts, your mortgages, taxes, home equity loans, any other debts associated with the property. Those are deducted from the market value, and that's how equity is determined. Normally, to make this calculation, you need either a paid real estate appraisal or a real estate agent can prepare a market analysis. Is that something that you do typically for people?
It is, and if they want to just get a quick idea of what their home price is, I said it earlier on in the show, but it fits in perfect right here. You can check out trustthedove.smarthomeprice.com, and what it does is it just gives you an instant home value, but for you can have an agent go in and check out the condition of your property, and if you added different things, and it may change, which will increase the equity in your property.
So from there, couples can choose one of three options to divide the equity. The first being the spouses can sell the home and divide the proceeds. You'd have to pay off any of those debts we determined that affect your equity. Any mortgages you have, any liens, unpaid taxes, not that you don't pay your taxes, but there could be outstanding anything. So less that, whatever's left, you could divide. Option B, one of the parties can refinance the home and buy out the other party. So again, that equity comes into play. It determines what amount that person refinancing should pay the other person to buy them out. So, and then at that closing, one spouse can sign a quitclaim deed at the closing and can have it recorded with the town or the county, depending on where we are, and that'll take them off the title. Option C, one spouse, this is if you have children, usually the custodial parent, so the one who has been given placement. You can have joint custody, but there's only one placement. That's where their technical address is going to be. That's their main home. So the custodial parent will remain in the marital home with the exclusive use and possession for a certain period of time, however that is that you've agreed on or how the judges said. For example, the youngest child graduates from high school. That could be the end of that term, and then either buys out the other spouse or sells the home and divides the proceeds the way we talked about in option 1. The court will also look at whether the person residing there can afford the mortgage, pay for the taxes, the homeowner's insurance, any expenses that are involved, and that also takes into account child support if there are children in the mix. We can talk about child support in another show if the listeners find that this is an interesting topic.
It's a pretty big topic.
Yeah.
Though it is.
A little tip from me, don't take your name off the title unless your name is also off the mortgage. Okay? Especially if the other spouse does have the ability to refinance. You know, it's tough if you are getting divorced at a time where your property is underwater or your credit's not that good and you can't refinance. Then I'm all for working it out because, you know, that's just the peace and love inside of me. But if the other spouse does have the ability to refinance, you don't want to be responsible for mortgage debt if you are not an owner of that home.
Yeah, we see that all the time.
It happens all the time. So, and this all comes out in the property settlement agreement that you and your attorneys are going to draft. And it's going to divide up all your other property that may not be real estate. It could be credit cards, bank accounts, the microwave, whatever you guys want to divide, the painting over the mantle, all that stuff. And usually most spouses, either through their attorneys or through mediation, can reach some sort of agreement on the property and what they're going to split. But if your situation is particularly contentious, the case can be litigated before a judge, and he could be the one that decides on the division of the assets and distributes them accordingly. So, I mean, you'll have more control over what happens if you're the one agreeing on the division with, your ex-spouse and your attorneys trying to mediate and trying to find a common ground instead of leaving it up to the judge, because you never know. You get the judge on a bad day, or you just don't know what he's going to do.
Too.
They're human too.
Definitely.
And do you want to leave something that important up to chance?
Yeah.
No. So, but again, every situation is different. Every relationship is unique. And I mentioned 3 options, but there's an infinite number of agreement scenarios.
Totally.
So, you have to do what's best for you and best for your family. But always engage an attorney so that you can get the best possible outcome.
Consult Teresa Santoro for some more advice on this topic or anything else regarding, the law behind real estate or title issues.